Hi, everyone. We're going to give everybody just a minute or two to join us, and we'll get started in just a minute. I'll give it just another 30 seconds, and then we'll get going. Okay. I'd like to thank everybody for joining us today. This is our third year of the Planning Today for Tomorrow series. Financial wellness is one of our 4 pillars of well-being, and in addition to investing in your future, it also includes planning for when you're not here, and also helping your parents, your partners, and spouses do the same. Today's speaker, Daniel Timins, who joins us from Exemptions Law Group, was one of our speakers last year for the Why Do You Need a Will? Daniel's presentation style and his ability to make legal jargon understandable was lauded by many of you, so much so that we asked him to take on the heavy lifting this year to encompass most of the topics for estate planning. So today is part 1, and next Thursday is part 2. The deck is attached as a handout, and as always, we'll take questions at the end. I'm going to be handing the webinar off today to my associate, Kelly Stykes, so she'll be monitoring the questions at the end of the presentation. Daniel, with that, I think we're ready to go, so I would like to turn it over to you.
Wonderful. Thank you so much, Jackie. I'll tell my wife that I was lauded at some point here. I don't know if that'll make a difference for her.
You never know.
And first, thank you for having me speak. Everybody, so you know, I am speaking to you here in what some people call lovely Midtown Manhattan and other people just call Midtown Manhattan. Some people call it far worse. You may occasionally hear a honking of a horn. I apologize for that. That I have no control over. One thing I will say really quickly is that your legal plan is one of the companies that you can use, is Exemptions Law Group. We're a law firm. We can help you with a lot of the things that we are going to be talking about today. So please have your questions available. One thing I will tell you is this: there is a lot of content here intentionally. I don't expect anybody to remember all of it, and I wouldn't expect most people to remember the majority of it. If something pops up, some suggestions that I tend to make is this: just have a pad of paper out, and if you hear me say you probably don't want to do this and it applies to you, write down that piece of paper, don't do this, or change that. I found that that's going to be the most successful thing that we do. Have your questions ready. I will answer them at the end. I'll leave us about 7 to 10 minutes at the end. And without further ado, let's get started on Trusts and Estates Part 1, everything to do with legal documents other than wills and trusts, though partially wills and trusts, Medicaid, and transferring of money. Here's a disclaimer: once you see it, you can't unsee it. Now you've seen it. So what are we talking about today? We're talking about money. That's what we want to talk about, or at least that's what we think about. That seems to be what we talk about a lot. And this is about family money and your money, specifically saving money on taxes, saving money on health costs, and any costs that courts would assess if something happens to you. Transferring money to other people and preserving family wealth. Maybe some of these things don't directly apply to you, but they may apply to a family member, like a parent or a sibling. You may want to help your parent preserve their family wealth, quote unquote, preserve for you, let's face it, and they can take advantage of several methods that we're going to discuss. The 5 topics that will get us to what we are talking about are legal estate documents, taxes, types of investment accounts. We'll talk a little bit about Medicare, and then we'll discuss Medicaid benefits. So that being said, let's begin moving forward. So, and as you can see right here, all types of interesting things regarding setting up this PowerPoint presentation. I want to thank Giselle Rivera for setting this up. She's the technical aspect of this, going to show that millennials can do just about anything, provided it's behind an electronic device. So the documents we're going to be talking about are the power of attorney, the healthcare proxy. We'll discuss what a living will is, a last will and testament, and a trust or trusts. A lot of this program is based off of New York law. You should know that a state law is based on the law on the state that you're in. Same thing with matrimonial and divorce law. If you get divorced in Nevada, you're going to be dealing typically with Nevada law, etc. Same thing with estates and health law. It's going to be the state that you're based in. Since I'm primarily based in New York, it will be a lot of New York, though all these documents apply with slightly different names in some states. The first document we will talk about is the power of attorney. This is an important legal document, and I've laid out for you exactly what it is. When you see numbers here in a presentation, there's a reason. They are full requirements. So here for the power of attorney, these are all requirements and all describe what the power of attorney is. It is a legal document, number one, naming another person who can make financial decisions for you, and you can give them the ability to gift your money while you are alive. So that's important to remember. When you pass away, this power of attorney is deceased. It no longer works. It is deceased as you are. Your power of attorney is also known as your attorney. In fact, that's a person who's making those decisions for you. They do not need to be a lawyer. The fact that the document is called a power of attorney just means someone else is representing you like an attorney would. So again, you usually name a trusted family member as your power of attorney. The document itself is typically a statutory form, meaning that each state has their own form. Now, under the full faith and credit clause of the Constitution, any power of attorney or any law, in fact, that's valid in one state is valid as to the next and all other states unless there's some other blocking statute that's put together. So in this case, if you live in New Jersey has the New Jersey state form. New York has the New York state form. California has the the California state form. You may have a financial company such as your bank. I pick on JP Morgan Chase because I work with them and I'm happy with them. They have their own power of attorney that applies to all JP Morgan Chase branches. Same thing with Vanguard, same for any Fidelity, you name it. The problem is it's only going to be good at that financial institution. So when you have a state power of attorney form, it's going to be valid in all states of the union, not valid outside the country. Other countries don't necessarily adhere to our power of attorney law. Now you can allow your power of attorney to do the following things. They can pay your bills. They can write checks. They can change your investments. They can move money from a checking account to a Bitcoin account. They can buy or sell your stuff. I can buy an armoire for my aunt who may not be able to make that decision for herself, or sell her dresser. They can file income tax returns, and they can bring lawsuits. So these are many of the powers that your power of attorney has. It's basically anything regarding your finances. So powers of attorney may also allow your attorney, in fact, also known as your agent, to gift your money while you are still alive. But you don't have to allow them to do this. You say, well, why would I possibly ever want that? Well, maybe if you have aging parents who are getting sick and get a stroke, they're no longer able to make their own financial decisions. Being able to gift will allow you, as their power of attorney, to gift their money, which allows them to procure Medicaid planning benefits and also to minimize some of their potential taxes. Now, the negatives is this: every time that you're allowing someone else to gift your money, you're dispossessing yourself of some wealth. This is typically what makes people a little scared to sign powers of attorney. But the truth of the matter is this: you'll see that they're still very important to sign. You can choose whether or not you want to allow gifting. Now, when you die, the power of attorney is canceled. It's just done. At that point, your will or some other transfer of your estate documents takes place. So when you pass away, your power of attorney is deceased. I want to make that very clear. Now, here are some tips when you have a power of attorney. If you have an aging family member, I always like to bring up parents, but there may be aunts or uncles. You may have heard my phone ring in the background. That's my aunt who I'm her power of attorney. What typically happens is that a bank may give you a little bit of a hard time if you show up with it and your family member is not there. If you have an aging family member who has a validly signed powers of attorney, take them to the bank, take them to their financial institution and make sure that it is logged with them, because then they'll ask your parent or your uncle or aunt, are you sure you want this? And they'll say yes, and then they're going to log it and it will be on file. That's the biggest problem that I find happening regarding powers of attorney. They are not dealt with before someone absolutely needs it to be in effect. Now, you don't need an original power of attorney except when you're transferring real estate. So if my mother has dementia and can no longer figure out what's going on from a financial perspective, I can transfer the deed of her house. I can transfer it to me. I can sell it to someone else for her benefit. And in that case, I would need an original power of attorney. Otherwise, a photocopy should do. The important thing to remember with the power of attorney is this: you should only appoint someone that you trust. The power of attorney can be looked at as a blank check. So in other words, if you're giving me the ability to write out a check from your account, I could just give it to myself and run away to Aruba. You say, well, I don't want that. Well, you do want your bills to get paid, but you don't want me to run away. The problem is I could break the law. It would be criminal of me to take your money, or not me, anybody, your family member you name. But the point is this, that if you don't trust the individual, you probably shouldn't name them as your power of attorney. Brings us then to the healthcare proxy. We've dealt with your finances while you were alive. Now we're going to talk about what your healthcare proxy is. It's, again, a legal document that names an agent that we call a healthcare agent to make healthcare decisions for you, and it gives them access to your protected healthcare information. It includes limitations on your care, and if you want any limitations on your organ donations, or not, I should have added. It allows or disallows your agent to continue your life support. So just like the power of attorney, we are naming someone else an agent to handle our affairs for finances. Here with the healthcare proxy, we're naming someone else to handle our healthcare affairs if we are unable to. Now, you may only need the healthcare proxy for a few hours, and this is typically what you need. And in fact, if you ever go into a hospital for just some routine surgery, they're going to make you fill in your own healthcare proxy that they have created. You probably want to have one that you've created instead. But let's just say you're going to be generally anesthetized for a few hours. No big deal, right? We do that all the time in this society. If that's the case, your power of attorney is in effect while you're anesthetized. So if the doctor comes out and says, hey, guess what? We found, I don't know, fill in the blanks. We found a watch inside your uncle's chest cavity. You know, do you want us to take it out? You get to say yes. So you get to make healthcare decisions. And then when your uncle wakes up, he's okay. The healthcare proxy stops. Of course, this healthcare proxy may be valid for the rest of a person's life and may be in effect. So if you have a family member who has a stroke, dementia, Parkinson's, or, you know, they're just talking to grandpa, even though he died 6 years ago, I've seen some unbelievably unfortunate things, and that person can never make a healthcare decision again, the healthcare proxy is going to be in effect the rest of their lives. So as you see, it can be for a short time, or it can be for the rest of your life conceivably, or someone else's life. Which brings us then to the living will. It's funny, I shouldn't say funny because it's a death document really. The living will has nothing to do with living, and it's not a will. This is the document that says pull the plug. People will say, oh, that's a do not resuscitate, a DNR. No, that's something that's signed by a doctor. The living will is signed by you, and it states what you would like happening if you're in a terminal condition, meaning I want to have a ton of opioids so I don't feel any pain. Number 2, if you're permanently unconscious, in other words, if you're in a coma, or 3, if you're conscious but have irreversible brain damage. Some people call this a vegetative state. The living will is the document that allows your healthcare agent to, quote unquote, pull the plug. That's what we say. Here's the standard language we have in there. I feel especially strongly about not having any mechanical respiration, tube feeding, antibiotics. You say, antibiotics, I want that. Remember, you're in a vegetative state. Sometimes an infection is ultimately what will end your suffering. And you typically say, I do want to have maximum pain relief, even if this treatment may hasten my passing. Remember, the living will does not name someone to make these decisions for you. It just gives that person the added authority. You're making a declaration and they can follow through with it. Now you say, well, why do I need a power of attorney and healthcare proxy? I suggest people should have a living will, but some people's religious convictions or personal feelings means they don't want a living will. That's fine, I don't begrudge them, but you need to have a power of attorney and healthcare proxy. And here's why. Many people that I work with, particularly people who are unmarried, no children, or just disinterested, they're basically people who don't feel like they have anyone they can trust to make these decisions, don't feel like doing these documents because it's difficult for them to face their life. They just don't know who they would name. They kind of review, man, I wish I had someone that I trusted to do this, but I have not enough friends, or I don't trust people, my family, I don't like them, whatever. That can lead to a problem. The people who don't do these documents and then become incapacitated have an issue because the courts of every state have a public policy purpose to make sure you can handle your own finances or health care. And so what will happen is you will go through what is called a guardianship. In some states, it's called a conservatorship, but it's more or less the court is going to oversee a person like yourself who used to be able to make decisions regarding their healthcare or finances and chose not to sign a power of attorney in a healthcare document. And they're going to say, fine, you had the opportunity to name who you wanted. Now we're going to take that opportunity away from you. We're going to name that person because you can no longer make the decision. You are incapacitated. Guardianships are gut-wrenching. They are expensive. They are intrusive, and they are avoidable if you have a healthcare proxy or power of attorney. Very important for you if you have an aging family member to make sure they have a power of attorney and a healthcare proxy. And frankly, you probably should too. So if you took out that pad of paper like I suggested when we began the webinar, I'd suggest you write that down. Now let's talk briefly about a last will and testament and a trust. The important thing to remember here regarding these documents is we're going to be covering them next week. So come back for part 2. A will is an original document, and it doesn't have to be typed. It typically is, but it can be written out, signed by you and witnessed by 2 disinterested people. If you say I'm leaving everything to my best friend and my lover on the side, Fifi, and I'm disinheriting my wife, and then now Fifi and your best friend are the witnesses, it's an invalid will. They are not disinterested. It states who will receive your assets that are still in your name at death. I'll explain what that means. And names a legal representative, someone named an executor who will wind up your affairs. You get to choose who will do that. Plus, you can name a preferred guardian for your minor children. Remember, the court will decide whether or not you made a good choice, but your choice lends a good deal of weight to that equation. And this document is submitted to the court that will oversee a process, legal process called probate when you die. When you're alive, you hold on to your will. No one knows of its existence. The most important thing is this, that your will only be probated if money is passing under your will, or property, not necessarily money. It could even be my gold ring, or there's a guardianship need to be dealt with. Plenty of people die with valid wills that don't get probated because no property is passing under that will. Be mindful of that. Now, like I said, millennials, they're really good at certain things I am not. Last will and testament, this is what is not transferred under your will. So there are certain different types of accounts that transfer property and it never makes it to your will. Basically, anything that has a named beneficiary transfers outside of your will. That includes a life insurance policy. You typically have a beneficiary named. Your IRA, 401k plan, or a pension plan, any of those things. Those transfer outside of your will because you've named a beneficiary. A joint account holder. If I pass away, my wife can go to the bank in tears with my death certificate and find out how much money's in the bank account, and then she'll really cry. And then she can just collect it. No probate necessary. A transfer on death account. If I have a bank account and I don't really have someone that I have joint accounts with, but I do want the money to go to somebody when I die, I don't want them to access it now, I can have it as a transfer on death account. That says this, the Daniel Timins checking account, transfer on death to Mother Teresa. If she was still alive, she just shows up with my death certificate. My will could say I leave everything to my wife, Michelle, but Mother Teresa is getting that account because it never makes it to probate. This is the important point that I'm trying to make. Not many of your assets transfer by probate. If you have a house that's solely in your name, transfers by probate. Let's say my wife and I own an apartment and I die. If we own it jointly, it goes to her outside of probate. She just gets it. When she dies, she's the only person named on it. Then it goes by probate. But certain things that have beneficiaries do not transfer by probate. If you have a family member who owns a house and they say, I want to live here the rest of my life, but I don't want it to go through probate, you can create what is called a life estate. Grandma creates a life estate over this property, leaving the remainder interest to her 2 children. Anything that is a trust, unless it's a trust created in the will, and again, we'll discuss that next time, and certain types of contracts transfer property, like a pre or post-nuptial agreement or partnerships. This is called, these accounts transfer by operation of law. That's a different legal process than probate, meaning it just kind of happens. You just need a death certificate to do that. We'll talk more about that next week, and I hope you show up for that webinar, because that's definitely a very interesting one, because it has to do with both you leaving money and you inheriting money, and how it happens and how you can minimize costs. This is far less costly than probate is. So that's what a will is not. So what is transferred by probate? It's basically any property that's still in your name when you die. If there's no beneficiary that we can ascertain the moment you die, we don't know who gets it. So what do? We look at what you put in your will. That's what the whole purpose of a will is. We don't know who gets it, so we need to look at the will. A bank account that's solely in your name, or any home that you own, any personal property, anything that's not transferred on that prior page, that operation of law. Any property that you say, like on your life insurance, I leave this to my estate, or if you leave your retirement plan to my probate estate, it now transfers by your will. I make a note here. Never, never, ever, never, ever, ever, never, never, never name your estate as your beneficiary on any operation of law assets. So we'll go back a page really quickly. Do not name any of these beneficiaries of any of these accounts as my estate. You just defeated the purpose. Now you're trying to avoid probate, and now it goes through probate because you named my estate as your beneficiary. Do not do that. Check all of your beneficiary accounts and make sure that you have not named my estate. If you have, talk to an attorney, ask them what to do. So, who must be placed on notice? I have a lot of clients who just say, well, I may disinherit this individual and I don't want them to know about it. It may not be a spouse. Like, let's say I have an aunt or uncle who doesn't have a spouse and doesn't have kids, and they say, well, I love my niece and I'm okay with my nephew, but this other nephew, he's a real schmuck. I don't like him. I want to leave everything to my other niece, or to my niece and my other nephew, and I don't want that nephew to know. Well, if that's her next nearest family member, the 3 of them, she has to put them all on notice. So let me explain this. If I have a spouse and no children, my spouse must be placed on notice. Even if I attempt to disinherit her in my will, she has to get a copy of the will. If I have a spouse and children, both get placed on notice. And by the way, my spouse, if I have no will, gets $50,000 off the top in New York, and then splits the rest of it 50-50 between herself or himself and the kids. A lot of spouses don't like that. They say, I want everything, of course, and most people say, well, I want my spouse to get everything. You better have a will that says that. That is not the default. Parents are not, or excuse me, spouses are not the only people that have a vested right. Children do as well. If your spouse predeceases you, or if you never had a spouse, or if you're divorced, your children receive 100% of your estate, and they must be placed on notice. And then grandchildren. And again, this is if you have no will, or if you have a will who's getting placed on notice. If you have no spouse or children, your parents get placed on notice, et cetera, et cetera, et cetera. So you have to place these people on notice, and we'll discuss this more when we get together next week. And then let's talk briefly about trusts. What are trusts? They're written and signed legal documents that name a creating individual, an administering individual, and a beneficiary or beneficiaries. It states the terms in the trust that shall determine how the assets in that trust shall be administered to. It avoids court oversight, and it continues to exist after you pass away. It's created while you're alive and then continues when you pass away. And it only impacts property that is owned by the trust. And you say, well, what does all of that mean? Well, here's a will versus a trust. Like I already said, when you have a will, it is public. It has to be submitted to a court when you die if you want it to be probated. Trusts are private. Trusts do not go in front of a court. When I'm trying to disinherit somebody with a client, we try to use trust because then it's not public. They have a lot of trouble figuring out what took place. If I'm trying to avoid the court having to rule on everything, we transfer it by the trust instead of a will. The burden of proof of having a will proven valid is on your executor, your financial individual. So if I'm disinheriting someone, I have to try to actively disinherit them. Whereas with a trust, the burden of proof is on that disinterested disinherited individual. They have to try to overturn it. The burden of proof means a lot in the legal world. Probate is slow and expensive. The good thing about trust is that the moment I have a death certificate from the deceased individual, I can begin helping their beneficiary or the next trustee begin administering to that trust. So the body doesn't even have to be cold yet, and we can already begin legal work with a trust. We don't have to wait for the court. Now, to execute a will, you don't need a lot of mental capacity. I mean, you clearly have to know who your family members are, and you have to have a general understanding of your wealth. If you say I have 8 kids and you have none, or if you say, hey, I want to leave my 500 acres in the Hamptons and you don't even have an apartment anywhere, you're not going to be able to execute your will. But it does require a very minimal level of mental ability and capacity, whereas a trust requires a good deal of mental capacity. Now, the good thing about a will is once you sign it, provided it's valid, it's effective. It will transfer the property. With a trust, you need to sign the trust just like you do a will, but you also need to fund the trust. The trust needs to own assets. So you actually need to change your deed. You need to name the beneficiary of your life insurance policy, the Margaret Smith Living Trust. We'll talk more about that next time, but it's an important point to bring up. Who are the parties to a trust? There is at the top a party that creates it. They are called the creator or the settlor. We sometimes call them the grantor. They create the trust and they fund the trust. They give it property by naming it after the trust. The trustee manages the trust property. They pay the taxes, they follow the terms of the trust, and then the beneficiary just kind of kicks back and enjoys their benefits. You say, well, what's the purpose of this? Why would I have a revocable trust? Because during your lifetime, it continues to be in effect even if you're incapacitated. Here's the thing. Remember these 3 parties from the prior slide? With a revocable or living trust, you create the trust, you are the initial trustee, and you are the initial beneficiary. If you're incapacitated, you could say, well, my spouse or my best friend or my child becomes the trustee, but I'm still the beneficiary. And if you're married, what the heck? Make your spouse the beneficiary too. And then when you die, it transfers the property. So you're all 3 of these parties. That's beneficial if you are incapacitated. And again, afterlife, a revocable trust avoids probate, it's private, it's a faster distribution, and there's flexibility. I can say if my beneficiaries have substance abuse problems, I don't want them to get the money. If they have creditor problems, I don't want the creditor to get the money. These are all things we'll cover next time. But now you got a taste of it, so maybe you come back next week. Then revocable trust, who does what? You can create it. You tend to be the trustee, and then later someone else is. And then the beneficiaries are you until death, maybe your spouse, and then your children later. Then, why irrevocable trusts? Well, there are only 3 reasons. I was fortunate enough to get published on NASDAQ's website just for doing this. An article I wrote, more or less, it hit me one day. There's only 3 reasons. Because you want creditor protection for yourself. They say, well, everyone wants that. Well, maybe, but some people more than others. Like if you're an OBGYN or construction or an architect, I always say, because, if you're one of those people you're going to get sued later this afternoon, they may want to have this trust. It's irrevocable is the problem, and you cannot be the trustee and the beneficiary. So a lot of people say, oh, I kind of want to be in control of my own money. Well, you can't be, and there's only certain people you can name as trustee. The second reason is to reduce estate taxes. The funny thing is, who is this for? This is for people who have a lot of money. If you have a problem with estate taxes, if you're wealthy, why don't you give me a call and let's go out to lunch? And tell you what, I will even buy you lunch. Those are the types of people who need to have irrevocable trust for estate tax purposes, and you'll see why later. And last but not least, to procure government benefits. For my mother, who I may want to get on Medicaid because she has Alzheimer's and I want to transfer her property out and have the government pay for her care, I will create an irrevocable Medicaid compliant trust. It must be irrevocable because the property that's going in there, I'm saying I'm limiting my mother's access to it. The basic idea of all of these, like I was saying, is you must give up some control. The trust can't be changed, and you cannot be both the person in control of the trust, the trustee, and the beneficiary at the same time. You can be one, you can be the other, but you cannot be both. So you will see, you can create the document, someone else can be the trustee, someone other than the beneficiary, and the beneficiary is someone other than the trustee. And that's all the time we have on trust this week. Come back next week. Now, understanding different taxes, you kind of know what these are, but I'm just going to do a brief refresher. Wages and income are based on taxed on what's called income taxes. Investment gains are based on capital gains taxes, and transfer taxes means money that you give to someone else. They're called gift and estate taxes. Now, both federal and state governments have some of these. I'll go back to that in just a moment. Income taxes, very simply, are broken into two general categories. God knows that income taxes are broken into like 10,000 categories. That's why, it's impossible to file an income tax return. Some people on the phone may do it themselves. That's great for you. A lot of people I know just look at it and they give up. They say, forget it. Taxes have gotten very complicated over the years. There's two types for this discussion. Number one is earned income. That's what everyone at Nielsen is doing right now. You are earning your income listening to me. That's pretty good. Some people consider that a task or a labor. This money that you are earning as earned income, meaning back-breaking, sweating labor, gets taxed not just income tax-wise, but also gets taxed for Social Security and Medicare. Those two components are taxed at 7.65% at your end. And believe it or not, Nielsen is also paying 7.65% for you. So make sure to thank the CEO. That was not a paid plug. And then there is unearned income, and that's from investments. This is not taxed on Social Security and Medicare. However, you can't use it to invest in your retirement plans. You know how your retirement plans, you get to avoid paying income taxes now? Well, investment income, you cannot do that with because it's unearned income. Now, here's my hint. Transferring money to certain people may decrease overall income taxes. That is a pretty straightforward thing that if you have something like a small piece of real estate and you have a tenant there, you may want to gift it to another family member in a lower tax bracket because you may be able to preserve more family assets. Capital gains taxes, this is what applies to your investments. Now, the funny thing is if I gift something to someone else during my life, they get it at the cost I bought it for. I wrote an article on this about someone who gifted their $2.7 million brownstone in Harlem. They purchased it for $20,000 and then they died very soon thereafterward. If she had just waited those additional few months, the beneficiaries would have received it at the date of death value, $2.7 million. Instead, the recipients, the donees, inherit the donors, the person who gave it to them during their lives, cost basis. So they ended up having to owe capital gains when they sold the property on $2,680,000. Yikes. So remember, with capital gains, it's important to realize that if you have a highly appreciated piece of property, why don't you hold on to it as opposed to gifting it, and you can gift the property that has pretty close to the same cost basis as what you purchased it for. Some people will say this, I bought IBM at 100 and now it's worth 50. So I want to gift it to my nephew so that he can get, $50 per share capital loss. And that doesn't work. The IRS, they're a sneaky bunch. And they say you can only pass on anything that has a capital gain and still maintain the basis. In other words, we're going to give ourselves, the IRS, the best ability to tax you. You can transfer anything that your beneficiary will get a gain, but not anything that they will get a loss. I'm going to leave that at that because I could talk about capital gains for a while. And then there are gift and estate taxes. Transfers during life may assess a gift tax. Transfers after death may assess an estate tax. In some states have an inheritance tax. Great example, New Jersey. If you transfer money to anyone other than Your children, your spouse, your parents, or your siblings, like let's say your best friend, they will face an inheritance tax if you give them enough money. It's a real pain in the neck, but New Jersey got rid of their estate tax, so I'm going to give them a break. I'm from Jersey. I don't tell too many people. I'm not necessarily proud of it, but what am I going to do? I'm from Northern Jersey, at least. Most people will never owe any estate or gift taxes, but the applicable exclusion amounts change frequently. I want you to keep that in mind, that just because you may not owe it now doesn't mean that when you die in another 40 years, it won't have changed. Now, here's the important thing to remember. There will never be an estate or gift tax on the following types of transfers. These are transfer taxes. I'm transferring money from one person to another. One spouse to another. Used to be husband to wife or wife to husband. Now it can be same-sex married couples as well. In fact, that was one of the big cases that made same-sex marriage closer to being legal. Spouse to spouse never has to pay a gift or estate tax. So you can have, who's a good billionaire right now? Well, we'll name Elon Musk, since he's doing so well in the media right now. He can give an unlimited amount of money to his spouse while he's alive, no gift tax. She can give it back to him when she dies, no estate tax. Next is you can pay for any and every U.S. person's health or education expenses in unlimited amount. Your best friend's son got admitted to an Ivy League school and you feel like you want to repay them for the debt. He saved your life at some point. That's great. You want to pay for his kid's college education? Go right ahead, provided that child is a U.S. citizen or a taxpayer in the United States. They don't even have to be a citizen. They just have to be residing here and paying taxes. Last but not least, you can give the annual exclusion. That is now $15,000. Sometimes I hear people say 10,000, sometimes I say 12. I say, well, that's correct if this was like 10 years ago. It's $15,000, and you can give $15,000 a year to any and every U.S. person. So you can give $15,000 to your child, and then $15,000 to your other child, and then to your best friend, and then the homeless person on the street, and throw me in there. You can give each of us $15,000 a year every single year. Now, let's say you're trying to help a child buy a home, and they come to you and they say, hey, mom, I could really use an extra $100,000 plus the $15,000 you gave me. Well, you give it to them because the handouts never seem to stop when you have kids. You still have an exemption that's available to you, and that's this amount. This is what I am saying. So after you've given an unlimited amount to your spouse, after you've paid for any and every person's education and healthcare costs that you want to, and after you give an annual exclusion gifts of $15,000 a year for every year for however many people you want to, you can still gift $11.18 million for federal gift and estate tax purposes. So during my life, I can gift $11.18 million in addition to all those things from the other slide. And then when I die, I can give $11.18 million. After that, I face a 40% tax rate. And anything that I give now, so any estate tax exemption that I use during my life, kind of equally diminishes the estate tax exemption for when I die. But this is the takeaway. Most people will never owe a federal gift or estate tax. Now, people say, well, what happens when the Trump tax cuts finally, expire at the end of 2025? Well, then it goes to approximately $5.6 million. That's still pretty good. That means you, and if you're married, your spouse each have $5.5 million that you can give or bequeath when you pass away without any gift or estate tax. It's a lot of money. Not a lot of people have this apply to them. Now, remember, there are gift and estate taxes for the federal government, but also for the state, and capital gains and income taxes. So just plan accordingly. Don't just start shooting willy-nilly. Just for time constraints, I will continue to talk, but I'm going to spend less time on this aspect. Here we're talking about custodial accounts. There are two in mind that I'm going to bring up. Remember, a minor cannot own property. Remember that going to Dime Savings Bank with your nickel or your quarter, and you put it into your bank account. Your parent was a co-signer on it with you. You can't leave money to a minor. If it seems wrong to inherit $2 million when you're 7 years old, guess what? It is. So we can give it in two different ways. One is called an UTMA account, where we're giving the money directly to the beneficiary, but indirectly. And the other is that we give it to a 529 plan, where we give it to the beneficiary indirectly by giving it to a specific purpose. An UTMA account is called a Uniform Transfers to Minors Act. You name a custodian who can invest the money in just about anything, real estate, stocks, Bitcoin. It's taxed at the child's lower income tax rate, and the child gets the money when they're 21 years old. Now, the positives of this is that it's cheap. It's an easy alternative to coming to an estate attorney like me who'll draft a trust and say, I will give the money to my grandchild when they're 21. Here's the downside. There's no creditor or substance abuse protection for the beneficiary. So if my grandson is a drug addict and he also has creditor issues and he's in the middle of a divorce and he has this UTMA account, it's going to get taken. So I don't like them for that reason. It's irrevocable. So if you say, well, now I have another grandchild, but I gave a whole bunch of it to this first grandchild or child, well, sorry, you got to convince the first grandchild to share the money. If the custodian dies, it may be hard to identify the assets if you aren't around because the statements go to the custodian. It doesn't go to the beneficiary. And if you leave an UTMA to a disabled child, and there's the sirens I told you about. We get this every day. It can ruin their Medicaid benefits. So keep that in mind. If you have a disabled beneficiary, you don't want to leave them funds in an UTMA. I don't like UTMAs. Pay the attorney and do the trust, all right? 529 plans, those are college education savings plans, and now they include expenses outside of college, so even high school. And it didn't have to be college. It could be a tech school. It could be primary school. It's basically an educational purpose-based account. There's an owner, a donor, and a beneficiary. The beneficiary tends not to be the owner. You can be the owner. Or if you're naming your nephew as your beneficiary, you can name your brother, his father, as the owner. And then you could be a donor. But the idea here is that you don't have to name the beneficiary the owner like you do on an UTMA. Now, the funds are never the beneficiaries. The owner can change the beneficiary, in fact, or they can even just take the money out. That's right. You can, if your child's giving you a hard time, take that money out of that 529 plan and make it yours again. Now, you do pay taxes and a 10% penalty, but only on the gain. And the beneficiary is never the owner of the money in the 529 plan. Now you can use it for primary, secondary, and college education. Withdrawals are tax-free. It grows tax-deferred. Now you have some limited investment options. When you get a 529 plan, there's only certain investments you can use. They're based on the plan, so you'll see. Limited contribution amounts, you can only contribute $15,000 a year per donor, so you can contribute 15. If you have a spouse, they can. If you have your best friend, they can also give $15,000 of their dollars. You say, well, I'll give my best friend $15,000 and then he can give it. Sure, good luck. I hope your best friend really is a best friend and a good best friend at that, because he could just keep it. And you can front load 5 years worth of contributions. So you can actually give $75,000 if you come into a big bonus from an estate or something else, or the lottery. Feel free to front load that 529 plan. You just can't contribute for the following 4 years. Let's talk very briefly about Medicare. I had a bunch of slides here. I think a lot of you will, when the time comes, probably do your due diligence and research. Medicare is a government program. You have to work for 40 quarters to qualify, or you have to be married to someone who qualifies for Medicare. You can receive Medicare if you're disabled for 2 years and 5 months and you've applied successfully, I should add. There are 4 parts to Medicare. There's hospital care, Part A, Part B, which is medical insurance, C, which is managed care, and D is prescription drug. Just for the sake of showing you what each of those means, I think I discussed already who qualifies for Medicare. Part A is when you go to a hospital. You know, when you pay for Medicare right now, it's paying for Part A. So you pay for Part A now. That being said, you don't pay for it when you retire, but what you do pay are copays and deductibles. You say, that sounds kind of like my insurance right now. Congratulations. Guess what Medicare is? It's government health insurance. So there you go. Medicare Part A, you still have a copay and deductible. The benefit here is that you pay for it now, but not later. You only have to pay for the copays and deductibles. You don't pay premiums. Part B, however, this is where they slam you. You don't pay Part B right now. But when you retire, if you're receiving Social Security, before you get that Social Security check, they're going to take out Medicare Part B from your Social Security. And it's based on your income, not just your Social Security. So let's say you have a bunch of government bonds and you have a CD that generated a nice chunk of interest, etc. Yeah, that's how they're going to determine how much comes out of your Medicare Part B. It really seems like everyone who saves gets the shaft in the end. But I got bad news for you. Welcome to the real world. It pays for doctor's visits and other certain types of procedures. Medicare Part C is managed care. You can have what is more or less a HMO or PPO insurance company based that runs your Medicare program. And Part D is prescription drug. I would love to share more about this. If you have questions, clearly you can contact us and we'll make sure that we can send you this slideshow if you're not able to get it through Nielsen, but I'm pretty sure you will. And then let's spend our last 5 or 6 minutes talking about Medicaid, which is long-term care paid for by the government. Medicaid is a health care and personal care program, I should add, that assists low-income families or individuals in paying for long-term medical and custodial care costs. It's a joint program funded by the federal government, but it's also run by the state and local governments. And lastly, it's where coverage exemptions and costs may apply. This is what Medicaid covers. You know, the things that you take for granted every day. I can walk from my bed to my bathroom. I can bathe myself. I can dress and feed myself. I'm continent. Well, that's a declaration we're all happy to say when it's the case. And I can toilet myself. In other words, it's the stuff you take for granted now. If you have a family member who has a problem with any of these things, they may be able to qualify for Medicaid, provided they are, not that rich. I'll show you what that means. Now, this does pay for healthcare providers. It's the payer of last resort, meaning you have to continue to pay for Medicare Part B, but then Medicaid picks up the rest. So that's important to remember. This is for the disabled. I don't know if that term is in vogue or not. You know, we don't call it disabled law, we call it elder law, but it can be for children who are born with disabilities. So it's not necessarily elder law. People who are not born with disabilities who may become disabled, like someone I meet who has dementia, if they've just been diagnosed, they're probably not disabled yet. But they may be. So they may be disabled already, or they may not be. So it's people who were born disabled, people who are not born disabled, but are now disabled, or people who may become disabled. Can also be for people who are disabled and shall one day no longer be disabled, but you may have to pay back Medicaid. So before you run around with scissors, make sure you speak to someone who knows how that works. There are 2 types of Medicaid. Everyone thinks of the right-hand side, the nursing home, but really what everybody wants, and there's not enough information out there about, is home care. It's called home or community care. You can have someone come to your home. You can have services paid for at your home. It includes physicians, dentists, and pharmaceuticals to some extent after Medicare Part B. And then there's the nursing home. Leave it to lawyers to think of something more onerous than the term nursing home. We call it institutional care. That sounds absolutely terrible. I didn't make it up, but I could have made it up. That's, of course, being in a nursing home or some other type of rehabilitative facility like a hospital. Now, what does home care cover? It pays for a caregiver to help you with those activities of daily living, the bathing, feeding, continence, etc., etc. Now, you aren't guaranteed to receive 24-hour benefits. I know that's later in the slide, but it does give you a certain number of hours per day where a paid caregiver will take care of you. They have to be qualified, though. You can't just say, I want my family member to get paid by Medicaid. No, 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 no. That's not how it works. Long-term care policies, you can do that sometimes, but Medicaid, no. It has to be a non-family member, and they have to be qualified and actually be compliant with Medicaid and through an agency. Typically, they can be individuals, but they still have to be qualified by Medicaid. Now, everyone prefers home care to nursing home care, of course. No one wants to go to a nursing home, but it's hard to get 24-hour care. And by the way, if you possibly need a nurse for 24 hours a day, you may need to be in a nursing home. Now, remember, the Medicaid aid doesn't have to clean out your toilet. They don't have to cook you a 7-course meal. They can heat up food, and they're supposed to heat up food, But this is for personal care. It's not someone who's going to do the cleaning and the cooking. They're just going to heat it up. So then we have grandma, and I hate to say grandma, but grandpa's usually dead at this point. Medicaid, but I don't want to go to a nursing home. Believe me, the nursing home doesn't want you if you're on Medicaid. They want to get paid out of pocket because the government says, well, we're going to give you nursing home a ton of people, so we want a discount. So the government, Medicaid, pays these nursing homes far less money than you do out of your pocket. It doesn't seem fair, right? Well, get used to life. I have news for you. Life isn't fair. You're probably at the nursing home because you need a nurse in the next 24 hours. Because they don't need you there and they don't want you there, but they'll take you because they have a spare bed. Believe me, you probably need someone to be there. Well, then you say, well, I'm better. I'm rehabilitated. I want out. Well, you have to be able to leave by having a care plan ready. They're not going to let you just leave. You have to have proper caregivers there. These are the resources you're allowed to have. You can only have $15,150. I'm just using New York. New York is the platinum standard. If you live in New Jersey, Connecticut, Florida, it's not as good. If you're a sick spouse, you're only allowed to have $15,150 in assets and $845 per month in income. Now, if you're married, congratulations. Your spouse can have up to about $124,000 in assets, or a little over $3,000 per month in income. You say, that sounds terrible. How can I ever possibly apply for that? Let me do this really quickly. Here are some of the exemptions and exceptions that are available. If you have a Medicaid trust, you may be able to live and still have more assets and income. And if you have a pool trust, then you still qualify for Medicaid, then those dollar amounts. Retirement plans, your IRAs are exempted from Medicaid asset restrictions. That's a good exemption. Your spouse can refuse to take care of you. I refuse to take care of my ex-spouse. There you go. Well, she refused to take care of me after a while too. And last but not least, you can use Medicaid promissory notes. You have to gift excess money. So these dollar amounts, if you're over this amount, either goes into a Medicaid or pooled trust, or you can gift it to other people. And then I can get you qualified, someone like me, for home care within 1 month's time. Actually, it's 3 months, but after a month, we can apply. The nursing home, though, is 5 years. That's the 5-year rule. So if you go to a nursing home, they're going to say, government's going to say, we'll pay for you, but you're going to cost us a lot of money. Any gift you made in the last 5 years, we're going to disqualify that gift. I wish I had more time for Medicaid trusts. I do not, because I want to maintain time for your questions. This is also kind of like, Medicaid planning course 4,000, how they talk about, they have in college those level 100 and 200, and then they have sometimes 300 or 400, and then they add like another zero to it for, I don't know, some crazy reason. But these are several of the trusts. If you have a disabled family member, this is what I want you to know. Don't leave them money outright. You can have a trust either that you create for them or they create for themselves. That will allow them to continue to receive their government benefits. If you leave someone money and they have problems and need Medicaid, you could get them booted off and your money could go to pay back Medicaid. You clearly don't want that. Talk to an attorney. They'll save you a lot of money. Medicaid, bad investments, and don't just take this and run with it. Let me just tell you, if you have a non-qualified annuity, I used to sell annuities. I used to consult on annuities. I'm not saying they're bad, but for Medicaid, they are bad. If they're in a retirement plan, they're not as bad. If you have those permanent life insurance policies with a large amount of cash value, that's bad. At $1,500 of cash value, you can't have another penny of cash value in your permanent life insurance policy and still qualify for Medicaid, because otherwise everyone would throw money in there and they would hide it. If you have an IRA or a 401k and you convert it to a Roth IRA, that's bad for Medicaid because you owe taxes, number one, and number two, you still have to withdraw the money over a certain period of time. I could explain that. I'm not saying Roth IRAs are bad. I'm saying contribute to your Roth IRA. I'm just saying don't convert your IRA to a Roth. And anytime you turn a liquid asset into lifetime income, because remember, we can transfer assets, but income we just kind of get. We have a lot of trouble controlling income. I could speak as to Medicaid for hours, and if you didn't go to sleep listening to me, I would thank you at the end. If you have an interest in learning more about Medicaid, please feel free to reach out either to the firm or ask Nielsen to provide you the opportunity to listen to another seminar. That does it for me, and that does it for you listening to me. I will ask any or answer any questions. You can ask them now. But if you have questions and you would like any of these services provided, please contact Zimmett Law Group. We will help you. And now I'll make myself available for any questions for the next 5 minutes.
Thanks, Daniel. That was very informative. You covered a little bit of everything on that one. It was really interesting to hear. I wasn't even aware of the giving people notice. So that was interesting to learn about that. I'll have to read more into that.
Yeah, come back next week.
If anybody has any questions, you can feel free to type them in the chat box. I do have one so far. Which documents can be created by myself versus a professional?
Great.
In addition to that, can you recommend professionals outside of New York State?
I could make recommendations for certain people outside of the state. This is what I'll say. I wish people luck when they make their own documents, and if they do it correctly, I don't begrudge them. They're not great clients. If they want to do it on their own, that's fine. And I understand attorneys are expensive. So you can do your own documents, and there are plenty of online services that do them, and I would pay for the online service. Of course, it's usually not the document that gets messed up, it's the execution. So I've had clients who figured, all right, they paid for this great will, and then they botch the execution. They don't have the right parties have their signature notarized, or they sign in the wrong place. And you say, how's that even possible? Believe me, it's not the document I'm concerned about. It's executing it yourself. Now, that being said, if you get it done right, you follow the instructions, congratulations. What's the best way to look up an attorney for anything? You want to make sure that they specialize. I'm a trusted estates and elder law attorney. I don't do real estate. I don't do business law. That's what you want if you want to do this. You want to work with a specialist or someone who focuses on a specific area.
Okay, thank you for that. The next question is there anything to consider when reviewing a parent's trust around the attorney who created it? This person in particular, their parents had a trust created and the original attorney was later disbarred. So another attorney updated the trust to ensure it was valid. Is there anything they can do to ensure the second attorney isn't going to have the same issues?
Yeah, I guess shame them and shun them into maintaining a good record. More importantly, I guess I shouldn't say that. You know, attorneys are humans too. Don't be fooled. So treat them like humans. Don't treat them like someone else either. Something more than human. But that being said, this is a concern where I have attorneys that get disbarred, lose wills, are no longer questionable as witnesses, or just die unexpectedly. You know, there's nothing you can really do to protect yourself from doing things wrong. You know, people will speed all the time. That being said, someone who doesn't have a bad record, you can look up and see if an attorney has a complaint. You know, they tend to be ones that are not going to have an issue with that. My bigger concern than them getting disbarred is them dying and holding on to legal documents. You know, they got to make sure, and you should make sure that you have a copy of all of your parents' documents, especially if your parents are aging. Or you have the originals and give your parents a copy. That's probably the biggest takeaway I can give anybody who has a family member that they take care of. Have at least copies, if not the original documents. Get their original will. If there's a Medicaid trust or some other trust, try to get a copy or the original trust and proof of their assets as well. Last but not least, make sure you have a list of their professionals, because sometimes the documents you can't find were created by other people like an attorney or an accountant or financial planner. So find out who they work with.
Okay, great. Thank you, Daniel. I don't see any other questions, so I guess we will go ahead and wrap it up since we're at the 2 o'clock hour. But I thank you for your time, and everybody remember to join next week as well for part 2 of the session. And I hope everyone has a great rest of the day.
Thank you. Had a wonderful time.
Thank you, Daniel.
No problem. Bye.
Thanks. Bye-bye.